නමුත් මගේ ඉඩම වටිනාකම මිලියන් 60යි. නමුත් දැන් මිලියන් 300ක් 400ක් වෙලා තියෙන පොලිත් එක්ක. ඒතර ගෙවන්න තියනවා කියන්නේ මුදල මිලියන් 200යි පොලිය 200යි. ඉතින් මේක යාලා කියනවා මිලියන් 300කට සෙල් කරනවා නම් ඔයා බේරන්න පුළුවන්. මම කිව්වා මට සතපාක්වත් එපා ඉඩම ඔයා ගන්න මම මේකෙන් ප්‍රශ්නේ මම බේරලා දාන්න. සභාපතිතුමනි වින්දිතයක් ඇටියට මට දෙන්න පුළුවන් සොලියුෂන් එක මොකක්ද?
Solution එක තමයි මේ කට්ටියව ඉක්මන් කරවන්න. Oh, welcome to the Committee on Public Finance. First of all, okay, so let me TW. So let me so we have 2 hours for this discussion. Originally we were planning to have the stakeholders only and then hear your views, and then we were to meet with the officials of the MOJ and the MOF and others next week. But considering request made by the Honorable Minister of Justice, Mr. Harshana Nanayakara yesterday afternoon, I agreed to combine these 2 groups. So that's why you must have been wondering why there are all kinds of different people here. So, Mr. Chanaka De Silva, now are you associated with MOJ in any capacity, or are you just an individual?
I am an individual. I have been invited to the association. So
do you represent any entity, or?
I do not represent any entity.
Right, okay, fine.
I used to be in the Law Commission, but I'm no longer in.
And you were involved in drafting this
I was the chairman of the subcommittee of the Law Commission.
And under that was when Minister of Justice was Ali Sabri, Mr. Ali Sabri, or when was it?
Mr. Vijitas Rajapaksa was there. Before that, also the Law Commission was there. The term of the Law Commission is 5 years. So since 20 to 25, the Law Commission was in place, and I was in that Law Commission. So there were several ministers doing that.
Sure. So how long do you need?
I do not need that much of time, maybe 10 minutes maximum.
Okay.
Yeah. Now, if you look at the law relating to insolvency and bankruptcy in our country, there are 2 aspects of it. One is personal and bankruptcies, and bankruptcies relating to partnerships and so on. And then we have corporate insolvency. Now, personal bankruptcy in our country was regulated by the Insolvency Ordinance, which goes back to 1853 or so, 1800s. Then we have the corporate liquidations, which are governed under the Companies Act. Now, if you look at the history of insolvency in Sri Lanka, the 1853 Act, at the time it was enacted, the ordinance, was actually a fairly progressive piece of legislation for the time. However, it did not keep abreast with the developments in law, and I think the second amendment or the only amendment to that was in the 1880s, and after that it has not been amended. So therefore, its use is extremely minimal. In fact, it is almost non-used. As far as corporate bankruptcies are concerned, we start with the winding up rules, which was established under the court's ordinance way back in the 1930s. Then the Companies Ordinance was enacted. Thereafter, the Companies Act of 1982 was enacted, and the 2007 Act was enacted. However, the 1982 Act or the 2007 Act did not do anything much in the area of insolvency and the reform of that law. That was because it was always felt that this was a very specialized area of law, and therefore it must be dealt with by itself. And as a result of that, we still function under the 1939 rules. The winding up rules is under the 1939 rules. But what is the problem in that? The problem is it is ancient, it's very archaic. 1853 was bankruptcy law, 1939 the winding up related rules, and it provides only for actually liquidation. In the 2007 Act, there is provision introduced for administration and compromise and so on, but those are very basic provisions. As a result of that, even though those are there in the 2007 provisions, it is very rarely used. So the problem in our law is, whilst there is provision for liquidation, there is no provision for rescue and rehabilitation. Now, as you know, liquidation is something which arises when the company is not liquid, when the company is insolvent. A company may be technically insolvent or illiquid, but still it may have assets. So if you allow it the opportunity of restructuring, or it may have a good business, if you allow it the opportunity of restructuring, then it may be possible to resurrect those companies. Or it may be possible even for individuals to resurrect themselves in the context of bankruptcy, but we don't have those provisions. Now, as a result of that, people are left to their own devices. So, very often, companies which can be resurrected are unfortunately subjected to liquidation because there are no provisions. And there was a clamor in the business sector to bring in provisions parallel to Chapter 11. Chapter 11 is a similar provision in the United States. Chapter 11, of course, is a very comprehensive, very complex provision. Those types of provisions may not be ideal for our country because it would be very difficult for us to handle it. Now, what this law does is, whilst it modernizes the provisions and simplifies the provisions relating to pure bankruptcy and pure liquidation, it also makes comprehensive provisions for rescue and rehabilitation, and that's why the title itself captures that. So there is provision made, and fairly comprehensive provision made, for the companies to be resurrected if it is possible. And similarly, in the case of persons, natural persons, to allow them the opportunity of restructuring them if possible. Now, what is required in those circumstances is a period of time, a breathing space for that to happen. And if the breathing space does not result in the resurrection, you will obviously have to go through the bankruptcy or liquidation processes. So this act is, or this bill is structured for the purpose of giving that breathing space for the people or the company to do the restructuring, and to do that in an orderly manner. So that is the purpose of this law. So I will not go into the greatest details of it. So there are two parts of this. The first part deals with actually the personal bankruptcy. If you look at it from part 1 to part 8 deals with personal bankruptcies, and part 9 onwards talks about rescue of companies and so on. So that's a very brief introduction of the history, the purpose, and the provisions which are there. As you can see, it's a very comprehensive one. It is practically two laws together to deal with the entire law relating to insolvency. So I will pause at that point and, if necessary, answer later.
Thank you very much, Mr. De Silva. That gives us the context. When was this first approved by Cabinet? When was this? How long has this taken to get to this point?
We were commissioned to do this in 2023. My recollection is that it was around June 2023.
Okay, got it.
We had a substantive draft which went to the legal draftsman, I believe, somewhere in February of 2024.
Okay.
Although it is comprehensive, it was it was drafted quite fast.
Okay.
However, the process thereafter took time, and understandably, it has to be gazetted, it has to be translated.
Okay.
And
So has there been any substantive changes from that original to now?
Not to my understanding, but there are certain changes of words and so on.
No, but nothing substantial.
No.
Okay.
Now, IMF missions have referred to this way back about almost 2 decades ago.
Yeah, so
You
it's
see,
coming
I mean,
for a long time. But what I want is the language itself, the drafting happened in 24. I was wondering whether there was any, like I said, major changes to which you said no.
Not to my understanding.
Okay, right. This, before we open this, one issue you have our team has done a wonderful job sort of concising this and also creating a presentation. If you like, we can share that with you yourselves. There's one little thing I want to ask. You have the companies and you have the individuals, right? What about MSMEs? How do you treat them? You say there is a sort of a bespoke arrangement, right? So does it fall more into the corporate, more into the individual?
It's sort of hybrid. It is somewhere in the middle. That was particularly because in the modern trends, MSMEs are dealt with separately. So therefore, there is a provision for that. It also is a tick box in relation to doing business and so on, whether you have provisions.
So
but even otherwise, it can work either way.
So is it like
a small partnership can work under the personal arrangements, or if it's a small company, it can go.
Who decides?
Corporate.
Who decides?
But if it is, the provisions are there as to how it becomes eligible.
Right. Is there anyone else who would like to make any comments from the government of Sri Lanka on this? Central Bank, the Minister of Finance, MOJ. Okay, then let's yeah.
Do you mind giving an opinion on the NIRA? That's the bank's outstanding, the liquidated that they have kept inside about 1.3 trillion. How does that come into this law?
I'm sorry, I did not know.
The thing that in 2016 we made a agency for all the insolvencies that are there in the banks to be updated. Has that been brought into this law?
Not to my understanding. I don't think.
No, it has special purpose vehicle, which was taking the 1.3 trillion in the banking system, which affects all of these small and medium. How does that, has that been provided or not?
No, not to my understanding.
So, before we open this, will there be, now there are already existing matters in court, right? And that is being dealt with within the existing law. There is now this new law that will come.
Yes.
Now, how will that be treated? Will they be redundant? Will they be able to change to the new law, or will they continue to be sort of prosecuted under the existing law?
Yeah, this problem always arises when we enact a new law. There are existing matters, and there will be matters which start afresh, and continuing matters. The law provides for that. Actually, the Interpretations Ordinance provides for that. My recollection is that it is Section 6. All continuing matters will continue under the old law, unless there is specific provision which states in relation to that. So if there are winding ups that are continuing, they will continue under the winding up positions. But if it is a new one that is coming in, then of course they can file that. They will have to file it under the new law once the new law is brought into operation. But if there is a pending matter where a court has not made an order, if the parties want to make use of the new law, they would be able to withdraw the matter and bring it again. That's up to them.
You think the district court system is capable of practically handling all these things once the new law comes into place? Or, is this something that the MOJ needs to consider seriously if it is to be implemented the way in which the government expects?
In order to implement this, we need to formulate rules. Now,
sorry?
We need to formulate rules and regulations, subsidiary legislation under this. This contemplates the formulation of subsidiary legislation, so that subsidiary legislation will have to be done. Now, for instance, that's why I said we are still using the 1939 winding up rules.
My question was, Mr. President's Counsel, on the capability of the district court system, right? not on the regulations based on this act.
Yeah. So one of the aspects is that you will, for implementation, you will need regulation. That's number one. Number two, we did have stakeholder meetings with the judges as well when we were formulating this, and actually, much to my surprise, they were very how shall I say? They were very excited about this law, because what they were saying was that very often they find that the companies that are sought to be wound up actually are capable of being resurrected, but there is no provision for it. Okay. Now, they were getting those provisions and they were very happy about it, because winding up is not the only remedy available. So that is a positive aspect. But with regard to competencies, this is a new law, this is a technical law. So in order to implement it, undoubtedly, you will have to have training programs both for the judiciary as well as for the public and private sectors, because they need to know how to work this. So that training will be necessary. We had the same type of situation when the new company law was enacted. It was necessary for people to become familiar with the law. And there were seminars organized and there were workshops done, both officially and unofficially, and that process needs to go through in relation to this as well.
So,
that is number one. Number two, this requires a professional set of insolvency professionals.
Correct.
So, initially we anticipate lawyers and accountants will be able to fill that. But the idea is that there will be people who are actually professionally qualified in that. And that needs to be developed as we go on. And there is a licensing authority to be established, which is the authority identified here. So we need to do that. The third thing that is required is official receiver. The official receiver will need to become very active. It might be necessary for the office of the receiver to appoint deputies in different areas who will be capable of handling this, particularly in the context of personal insolvencies, lower threshold insolvencies. They may not have assets, they may not have income, so there may not be someone who wants to take up that position. There is no money in it. So how do you implement that?
It's like a public defender type thing? Or what?
Like a public defender type thing. Even now, there is the office of the official receiver. But the office of the official receiver is, how should I say, functioning in very rudimentary form. There is an officer in the company registry, I think it is a deputy registrar or something like that, who functions in that capacity. It will have to become more robust. So those organizations will need to be there. And there might be, probably needs to be decentralized. Okay. And at least one in a district might be necessary.
Chairman, can I?
Yeah.
Can I ask the question? Now, while this law is going to be proactive, how does it help insolvency of people who are losing their houses, going to the debt bankruptcy in 2022? How does this help? Is there an expediting process? Because the inhuman activities are taking place while the laws are coming to place. How would you set that in place?
Okay. It's a bit of a practical question, but I will answer it to the best of my ability. That deals with personal insolvency.
Yes,
right?
personally, more.
So in those circumstances, look, at the end of the day, if somebody has borrowed money and given security for that, you have borrowed the money and it is your obligation to pay. If you haven't paid, you have failed in your obligation. Security is given for the purpose of securing the obligation. At the end of the day, most of this money is also public money. It comes from banks, it comes from other financial institutions. So that also needs to be protected. So invariably, if you have given security, that security is liable to be sold for the purpose of paying off the debt. That's the reality of life. That's why we give security for borrowing. Now, that being said, the problem is you enforce it even in situations where it can be restructured or resurrected. Now, what this bill does is it gives the opportunity for that to happen. And it gives for opportunity for that to happen not in a private manner, but under supervision, under a regulated system. Now, at the end of the day also, if it can't be sorted out, then you have to go through the bankruptcy process. Now, what does the bankruptcy process do? Bankruptcy process gives the ability for a person to start afresh. So, if you have no assets, no income, but you have a debt, and let's say the debt is below 5 million, what do? No assets, no income. He can't pay. If he can't pay, he can't pay. And the risk is taken by the creditor. So in those circumstances, one goes through the bankruptcy proceedings. There is an orderly system of collecting money and paying, and if it is not finished, at the end of the day, the bankruptcy is declared, the bankruptcy order is made, and that's the end of it. That is what bankruptcy is, just like in the case of liquidation. The same process is there for liquidation. So for people who, no asset, no income situation, liability is under 5 million, I think you can have a conclusion in about a year. But if it is a little more, let's say about 25 million, medium level.
Do you mind if I interject you?
Yeah.
Now, I'm very clear you're coming in a very clinical way. My question is on that. If you are held responsible for act of your own, then what you're saying is logical. But what if it is imposed on you, which is well beyond your control? On the situation of 22-12 April, where the interest rate went from what you are paying at 9-10% goes to 35-40%. Then you are basically called upon to pay some creation that has not been done by you. Now that is where all these problems that lie. That is the insensitiveness which I'm looking at. Is there a fast track? Is there a way forward? Can we exclude that period? Etc.
That is not.
So, that becomes just one moment, right? Now, that becomes a public finance matter to the Ministry of Finance.
Yes.
Whether, I don't know the central bank, but
is there
it is
a quick process from your legal aspect? Can you look at this period? We can look at it in dispense in 3 months. Or we basically, bring this under.
It's
Yeah,
not
I
in
think
that.
we might have to look at regulations.
Regulations.
Yeah,
When,
but that's what you're going
when
to
the
look at, whether
authority
we
is
can bring in a
created,
provision or
we might have to do some
we
regulations.
basically take that component, that period out for
Am I right?
2
Because
years.
it's not in that.
See, this is a piece of general legislation.
Yeah.
Right, okay.
So it doesn't deal with a
So that has
particular
not dealt
topic.
with.
No.
No,
that is-
Okay. So shall we just now get the views of the industry stakeholders? We have a whole number of them. I don't have any preference. We can break it into sort of 2 or 3. One is sort of yeah, I have a list. No, because there are sort of technical, sort of tax-related matters, then legal matters, economics-related matters, business-related matters. So we can just go.
So we'll go with either chambers or think tanks or something like that.
We have 15 or 10.
Yeah.
15
So okay. Let's start with the.
Institutions.
Yeah. Let's start with the Chartered Institute then.
From the Institute of Chartered Accountants, I think our duty is mainly to make awareness and to upskill our members in terms of doing or getting this work done. So far, we have established a separate committee for that. The committee is named the Regulatory Commercial Law and Regulatory Compliance, and we have started the work with organizing certain workshops for the members. So the first one we have already done on alternate dispute resolutions, and the second workshop is planned by the 3rd week of May on this particular bill, Insolvency Act. So likewise, we will be going ahead with the faculty and the committee in upskilling our members.
Your job is to make people aware of this.
Especially our members, and if required, the public also.
So as Chartered Institute, you don't have an opinion or observation on the gazetted bill as it.
That we will be doing now. We have planned a workshop.
No. What I'm saying is before it get enacted in the parliament, you don't have any observations or recommendations? Nothing.
Not.
Okay. Except your members can become insolvency practitioners, can they?
Yes,
Yeah,
yes.
there's an opportunity.
Yeah. So new business line. Okay, right, fine. Then shall we go to Mr. Suresh Pereira at KPMG?
Yeah, thank you, sir. I received the invitation to attend this on Friday. So what I've done is during the weekend I have gone through some of the sections, or basically skip through the thing. So to me, I identified 8 issues in relation to taxation, but I think most important thing, I don't think this has been communicated to the Commissioner General Inland Revenue with regard to this bill, because there are so many tax related things stemming from this bill. So I think now, according to what I heard now, you are planning to enact this on next Wednesday. I can compile a list of the things and give, and I will just give a summary of it today. But I think that will require amendments to the Act. Or maybe, so if the timeline is to be honored, then maybe at the committee stage level, those amendments to be considered.
Well, actually, you
So
don't
I
need, just one moment, Mr. Pereira. I mean, we value your contribution. We read what you write and you make a significant contribution to our discussions also. The issue is regulations haven't still been formulated. So not necessarily you need to amend an act. You can use the regulations to bring in perhaps
No, Harsh,
certain
I
amendment.
think there are certain provisions in the Act when you read also certain actions get ceased, right?
So,
And passed into something. So when at that time does the tax law comes on top, or this comes on top, is probably one of the concerns that is getting highlighted, right? Am I?
Can I make an observation
Yeah.
in relation to that?
Can we let him finish, please?
Okay.
Yeah, so with regard to the tax issues, I think I'll divide this into 3 categories. First one is the priority ranking. So now here we do find a cap being imposed with regard to the state or the inland revenues claims with regard to the past taxes. So there is, they can claim only 1 year of income tax, 4 taxable periods from the tax VAT, that means again 1 year, and there's a reference to turnover tax. Turnover tax is not a tax in Sri Lanka now. This was abolished many decades back. So I think that should be replaced, and the appropriate tax, this is the social security contribution levy or any other applicable taxes should be included, because turnover tax is an archaic tax, it's not relevant. So then also I find there is a mismatch that can happen, because tax liabilities applicable, the taxes, default taxes are assessed in Sri Lanka after a time gap. There is a time
Honorable
period
Shah,
given.
if just to
So now what
interrupt.
happens is, if this
Mr.
delayed
Suresh, if you can refer to the specific sections, it's easier for us to follow. If you have the sections with you, I mean, it's.
yeah, I don't have
Yeah.
that with me right now.
You don't have
That's
it,
as I
no?
said,
It's
basically I went through this
Yeah,
only
it's
during the weekend.
this is 4th schedule, priority on tax.
Yeah,
claims
4th
in
schedule,
liquidity.
correct. 4th schedule, item number 6,
Fourth,
page number
yeah, item
531
number
is
6.
the page number 531, 4th schedule. Item number C is the reference to the turnover tax.
2C.
Yeah, C, you can, item C, page number 531.
Yeah. Yes, please, Mr.
Yeah,
Pereira.
so there can be a mismatch with regard to the timing of the assessments, because it becomes a liability, or you find out the issue on when the assessments are raised. So in Sri Lanka, moment you file the tax return, assessments are not raised. There is a time bar period, so department has the time to raise assessments, and so that because of that there can be a mismatch with regard to this tax claims also. Then there is no reference to the what will happen to the one-off taxes that we have in Sri Lanka. For instance, we had a tax called surcharge tax, we had a what you call the super gain tax. Now what is the situation with regard to that? It's not clear in the Act. And then we also have then there is a repeal of the section 168 of the Inland Revenue Act. So in other words, what happens is we are not going to have 168 in the Inland Revenue Act. So we are going to have a, how do I say, a hole in the Act. And what is happening is the tax rules pertaining to, say, the insolvency, etc., are now being removed from the Inland Revenue Act, and it is going to this specific statute. In my personal opinion, I don't think that is a good idea. So what we are doing is, we are, when all the tax rules are there in the Inland Revenue Act, it is in an orderly manner. What is happening is not illegal, it's legal, but I think from a systems point, it's better to have all the relevant income tax statutes in the Inland Revenue Act, not to remove it from the Inland Revenue Act and include it into the specific taxes. For instance, if I give you an example, let's say we do have a, let's say insurance. The tax law pertaining to insurance, you can have it in the Insurance Act also, Regulatory of Insurance Industry Act. Or you can have it as it the way we have in the Inland Revenue Act. So when it's in the Inland Revenue Act, it is easy. All the industries are all concerned. But if you create a situation where you remove sections from the Common Inland Revenue Act and then try to include into each specific industry, the study of the tax, the application, it's going to be inconvenient. So I think that idea is not good. So in other words, the relevant amendment that is coming up should be included into the Inland Revenue Act, not the tax rule to be contained in the, included in the specific industry issue or the specific part of the statute. That's something to consider. Then something again, I think we have to get a observation from the Commissioner General Inland Revenue, because we do find Crown preference is being repealed here. And
What preference?
Crown preference, that is basically the debt due to the Inland Revenue Department. Normally in the order of preference goes to the top, basically, normally in other countries. Or
this
other,
is at
it
the
depends.
bottom,
It's a practical preference, so it's something we have to ask whether Commissioner General will make a claim in relation to that. I'm not looking at it from the state, not the...
It goes to the bottom, because of insolvency, people have to be paid, and then only later the
Correct.
tax.
So where, in the ranking, where is it? I think you have to get the idea from the Commissioner General also where to put it, where he wants it, basically. Now,
Yeah.
there's a huge amount
The
of
list of
taxes
priorities, what you mean, right?
Yeah, exactly.
Yeah. Is that it?
Yeah, so then again there's a reference to section 175. There's a 175 the Inland Revenue Act again is getting amended, and now here we do find personal liability of the bill appointed liquidators and the receivers are being covered, but they don't carry personal liability. But then I do find with regard to the administrators and the deed administrators are not addressed. So it's incomplete, I think, to me. And then again, with regard to the moratorium and the tax debts are treated as included debts. So it can be discharged. We have to again see the appropriateness of that. So now what I'm doing is basically things that came to my mind during the weekend I have jotted down. But these are policy issues to be analyzed, right? And then we have the most important thing is now when we go into, how do I say this, restructuring or trying to rehabilitate, rescue. So there will be transactions involved. So these transactions trigger both direct and the indirect taxes. So now because here we are trying to give relief to the party, trying to rehabilitate, trying to rescue, but this rescue action itself triggers both direct and the indirect taxes. So whether there should be relief given for this transactional related taxes during this stage is something, again, I think we have to consider. So say debt restructuring tax cost, whether this debt forgiveness, etc., basically, whether those should be relooked at. Then we do have the less carry. Sorry.
That is not covered in the law, Suresh?
No, so it's the ideal thing, I think, is now here is a company that is not doing well, and so we are trying to rehabilitate. So when you are trying to rehabilitate, certain actions we have to carry out. So when we carry out those actions, all commercial actions have direct and indirect tax consequences. So if there's extra tax liability coming in this activity that we are going to carry out, I think we should give them relief in relation to those taxes. Yeah.
So that is like
Because
financial.
if the interest is written off, there's already charged
Yeah.
tax on that.
Yeah. So I think, is that it, Mr. Pereira? Or?
And also, no, there's some, then under section 64 of the Inland Revenue Act, when there is a change of ownership, there are certain tax consequences. So I believe the so the rescue or the rehabilitation may also involve the act of change of the ownership. So this section 64 will have consequences in relation to that incident also. So it's again another point that we need to delve into and see whether we can give some relief there. So those are the most of the things.
Okay.
But I think when you go deep into these provisions, there will be more issues. In other words, I think to be fair by the Inland Revenue officers, when I tried to contact them, when I contacted them, they are totally unaware of this bill coming. So because there are many tax aspects in this one. So again, as I said, the timeline, if you are targeting Wednesday, then they should be, still there's a window because of to the committee stage amendments to bring this thing in.
Yeah. Yeah, just one moment, please. Is that all, Mr. Pereira?
Yeah, for the moment.
Right. I mean, these are very valuable comments. So, I mean, we still have time, and committee stage amendments are certainly possible. What I would request you to do is, prepare
if there are glaring issues, like
Yeah.
we listen to others also,
Yeah.
instead of committee stage, why don't you refer it to a standing committee?
Yeah.
And then take about a month and get it all.
Yeah, so that's what we will discuss at the end, no?
Let's go through.
Yeah, let's discuss all that at
I
the
think,
end.
but,
Let's go through
I
this.
think the Justice Ministry has to say something.
Yes. So that's what I'm saying. So let
No, but can the
that-
finance ministry also respond to the fact that IRD is not consulted? I think that's a very important point. Finance ministry, no? I mean, yeah,
I'm
just
from
the
the
ministry.
Ministry of
basically
Justice.
finance ministry has to take it.
Every cabinet paper is referred by the cabinet to the finance ministry. Surely the finance ministry would have given
So
their
that's why,
observations.
is there somebody from the finance
approval for
ministry
this.
here?
Yeah,
They
the
should respond to that.
CST?
Yeah. So what we'll do is, shall we wait till Honorable Lakmali, shall we get everybody's, the stakeholders? Yeah, it
That's, I
seems
mean,
like
we,
a serious
we
issue.
agreed in the beginning, so we'll get the comments
Yeah.
and let the officials stay.
That's right, yeah.
And we'll go.
Yes, Mr. Yeah. Mr. De
correct.
Silva, yeah.
If it's only required, you can respond, otherwise you can reserve your comments.
Two specific aspects that I would like to address. One is about addressing the Inland Revenue Department. We did consult them at the time it was being done. All these changes were presented to them, and my recollection is that the Ministry of Finance itself contacted them, and it was with those consultations that this was done. So that is number one. Number two, the questions about priorities was raised, about 4
Yes.
periods and so on. Priority list has not been changed. It is substantially the list that is there in the current act. There is no significant change in that. Now let me read that. That is Schedule 9 of the Companies Act, current Companies Act. Preferential claims. First comes the liquidator. Obviously, because he is the guy who is liquidating, he has to be paid, otherwise you will not have a liquidator. Following the liquidator comes these. After paying the claims referred to in paragraph 1, the liquidator shall next pay the following claims. A, this is the current Companies Act. All provident fund dues, employee trust fund dues, and gratuity payments due to an employee. These are collected from an employee, they must be paid. 2, B, income tax charged or chargeable for 1 complete year prior to the commencement of the liquidation. That year to be selected by the Commissioner General of Inland Revenue in accordance with the provisions of the Inland Revenue Act.
Sure, okay.
Next one, turnover tax chargeable for 1 year. Value-added tax chargeable for 4 taxable periods. Same. These were not changed.
Okay, all right.
But that,
problem
that
there
I
is
think
should have been
Suresh's
changed.
point, Chanaka, is that
Turnover
then
tax is
will
not
it
there in
give
Sri
rise
Lanka.
to the insolvent company being made to run if the public property things are paid? Will there be monies to run the company?
Right.
I think that's his point.
Two aspects to this. I think there was a valid point that was made. The transactions, when they are done in this, might attract direct or indirect taxes. Yes. But that is not a matter to be dealt with in the Insolvency Act. That's a taxation principle. So in the taxation documents, those will have to be dealt with. If it is felt, because that's a revenue matter. If it is felt that revenue protection has to be given to them, that you should not be taxing these in these situations, that must be done in the taxing statute. Right? And the other thing that was raised about repealing a provision in the Inland Revenue Act, that was very carefully selected, whether we are going to do it there or here. It could have been done either way. But that provision relates to insolvencies. Insolvencies happen under this. So it is more convenient for all insolvency provisions to be there.
But you just now said that the inland revenue on the taxes attracted during the restructuring process should remain in the tax legislation.
Taxers.
Yeah.
Because
so
that's
similarly,
that is whether a particular activity is going to be taxed or not.
during the insolvency
During
restructure.
the insolvency period
So
of
this
process.
is also the same.
Yes. Not really.
Why?
Not really. This is about how you deal with the proceeds.
Yes, still it has to do
how
with
you
taxes.
deal with the it's about the conduct of the insolvency.
Right. So we
but
can
not about
right,
taxation relating to
right.
transactions.
So we noted that. So I mean, these are valid points. Like you said, it could have been done this way or the other way. So perhaps you can take a call on that subsequently.
Yeah.
So can we invite on the, if you go, anything else on tax related matters that Mr. Pereira spoke about? Nitya Partners, FJNG, Diseram, Thilan, Vijay Singh. No. No? No, ENY is not here.
Honorable Member, can I speak then?
Yes, Mr. Vijay Singh.
Thank you. I must qualify and say, sir, that I received the draft legislation only yesterday, and I managed to glance through it only today, so with due respect to my good friend Shanaka. So if I may say
you don't have to stand, Thilan, if you can see.
I can see you better, actually.
Okay,
so if you don't mind, I'd like to look at the head table. When Sri Lanka was going through its economic crisis, there were two pieces of legislation I was crying out loud for enactment in this country as a means of capital aggregation for economic transformation. And those two pieces of legislation were insolvency law and LLP law, none of which we have in the country at the present moment, because there is plenty of capital out there in the world, but the legal and tax frame, limited liability partnerships, because that's what allows you to aggregate funds in a domicile jurisdiction without the cascading impact of taxes. So that's why you find even the fund promoted by one of our banks was incorporated offshore. And I'm at the moment working with a Singaporean company to create another fund, but it will all be incorporated in the Cayman Islands. And the port city law is grossly inadequate for that purpose. So that's a separate subject altogether. So in the case of even this legislation, honorable members, I look at it from the context as an investment banking practitioner who has attracted a lot of money into this country as well as forming local investment. Does it move the economic needle adequately to allow for recycling of assets and capital, which means when something goes under, the process of resuscitating these assets, does it go through a properly structured framework with time-bound, time limits implemented? And in this context, what I wanted to point out was that I as an investment banker have struggled, despite there being large-scale assets on the one hand, where it appears that the owners are too big to fail, the banks keep these assets in their asset book without any prospect whatsoever of those loans being repaid, because of the way in which banks are also prompted to behave by virtue of the inadequacies of the Parate law. Now, there needs to be a compulsion to make sure that there is no one out there who's too big to fail. Now, why I say this, honorable members, is that so far, last year, my investment banking company, we brought in more than $50 million for distressed assets in this country, the largest being Blackstone, who bought over the parent company of Altair. And $50 million came into this country. Similarly, there's at least $100 million of pipeline looking at distressed hotel assets. Now, I don't want to mention names in this situation, that there are hotels sitting on the books of both finance companies who do not have access to Parate and bank balance sheets, who rely on Parate and other ingenious balance sheet management methods to either keep these assets on their balance sheets and take absolutely no action because the large companies are too big to fail. Now, there should be a time-bound compulsion through the insolvency law, like in the case of India, to prompt, after going through a proper process, for these assets to come to the market so they can be recycled and repositioned. Because I maintain, honorable member, that bank balance sheets as well as land on which these assets sit on are national assets, because the banks can lend these monies to other sources. So therefore, the point I would like to make, in the case of the smaller companies, where the banks sometimes do not hesitate to execute Parate execution, because while on the other end of the spectrum, the big boys are too big to fail, the small guys tend to be put through the Parate process at great distress. Now, the actual way of doing this and how it has happened in other countries, the small guys have been aggregated into pools, what we call bad banks, so that large amounts of capital can come and look at all these small assets and see, in the first instance, can you work with the owners of those assets to resuscitate them? Now that provision also is absent, I feel, from an economic planning perspective. So the way I look at a piece of legislation, honorable members, is it a marketing instrument to attract capital, whether it's local or foreign, into recycling of assets that are distressed? I would like to conclude by adding that I hope my good friend Shanaka has followed the Indian framework, because unfortunately I didn't have the time to study the specific law itself. But having studied the Insolvency and Bankruptcy Code of 2016 of India, now it is very clear that non-performing loans on Indian bank balance sheets went down from 8 to 9% to 2% or less upon the implementation of the Indian Insolvency and Bankruptcy Code. Now, in India, there are bankruptcy boards. I believe there are similar instruments that are being proposed for this new legislation. Then there's, for the legal aspects, the question you raised, honorable member, there's a national company law tribunal through which the legal cases are expedited as opposed to relying on the magistrate's court. And then there are targeted time frames within which the revival process needs to be completed by law. The minimum is 180 days and the maximum is 330 days. So there is a legal time-bound time period for resolution of insolvency cases. And then there's a committee of creditors, I believe there's similar provision in this law, that decides on the restructuring, sale and liquidation. So in summary, it's a creditor control model. Now, in the case of the current Parate law, only banks are considered as creditors. Now, I can certainly tell you, I have been asked to look at the case of Krish. Now, Krish, there are multiple creditors, but we do not have the legal framework, and some action has been taken for liquidation of the Krish project, and it is there as an ISO at the moment in Colombo. And I believe laws such as these should help the UDA, the government, the creditors, including contractors, not just the banks, to have an equal say, along with the owners, in resolving the matters and failing which within specific time frames to move towards liquidation. And then the other aspect where everyone gets stuck, honorable members, is on valuation. Now, on the one hand, the owners naturally have... I can conclude.
I'm just reminding of the time.
Yeah, so to summarize, I believe that time frame should be as part of the law, and we must look at, like in the case of the Indian model, to at least one state-backed bad bank to be created, so that when everything else fails, you can pass these assets on to the bad bank.
Thank you, Mr. Vijay Singh. I mean, this is something that we have been contemplating here for a number of years now. The bad bank has been coming and coming for a long time and hasn't still arrived. But he makes an extremely valid point, and that is a bigger context, I think, even from a public finance point of view. You know, how do you attract capital so that you can give it a new life, right? And if you give it a new life, the kind of investments that he's talking about becomes possible to be attracted. So, I mean, are there any specific suggestions you have, Mr. Vijay Singh, in terms of making amendments during committee stage, or are you just making an overall sort of plea that we need to look at these matters?
Honorable Member, if I can have 2 days, because as I mentioned, I looked at it only this morning.
Yes.
If that is possible, I can.
Yeah, that's possible. Yeah, that's
I can
time.
come back with some comments.
Yes. Can I ask along the same lines, Mr. Jaffarji, for your comments on this?
Thank you. I was also invited only last evening, but I have previously worked in 2024 with Chanaka, some of the World Bank initiative committees on this. I only have very general comments. One is that this law is fundamental for the operation of a market system, because failure is an integral part of any market system. And all a bankruptcy law tries to do is to come up with a framework to resolve contractual relationships. There is a total misunderstanding that these kind of insolvency frameworks will significantly impact only one set of creditors, the liability stack of any economic entity. So if you take any kind of a business or any economic entity, they have a degree of stakeholders, and the residual interests are only the equity stakeholders. So most of the political conversation is about just one set of stakeholders when there are a number of stakeholders. So a law like this will actually permit more capital to flow into the economy, because it will lower the cost of capital, because there will be a more predictable framework of how to resolve in case of failure. The second thing is, what will happen in the debate, etc., is the financial institutions will get vilified. But
what?
The financial institutions will be vilified, basically. But the reality is, this law, as Thilan tried to allude also, covers many different other creditors. So, for example, trade creditors. And my day job is in the capital markets. Now, the banks have a priority and a superior recovery mechanism than other debt instruments like bonds, etc. This law will basically even the playing field. So therefore, it has many ramifications of improving the capital system in the country. So as I said, mines are more generic in nature. My specific things, what Chanaka said about this priority, who gets this thing, the Indian system took a slightly different viewpoint. For example, the tax is not a priority. They said that in the case of a bankruptcy or insolvency, and if there was some kind of rework of the creditors, they said that the tax is going to be an equal stakeholder in the economic interest of the entity. So this is a very political decision that will have to be taken. And if you ask me as a think tank, I would think that if the state has a claim on economic interests of a business through the tax system, then it should not necessarily be prioritized, because basically the other creditors also took equal risk. So they should be on equal terms in participating in any kind of reduction in their interests. That's a more philosophical view that I have. And since we looked at India, they took that view, that the state will be equal to all the other creditors. So why are we prioritizing them?
We are not.
No, I think, Chanaka, am I correct that they are a priority?
But it is at the bottom.
Yes and no. Yes and no. I wanted to address this at that time, but I didn't. I just referred to the priority model in the current law. But that was precisely the thinking. We prioritize only a small amount of that, because at the end of the day, the state is also public. So that's why 1 year of tax. After that, they stand in the queue with the others. So only that 1 year's tax is prioritized in respect of every type. And that was a conscious decision it was very, very carefully taken.
But my thinking is that even that 1 year, which is the most recent, right? I mean, a company is trying to restructure because it's in trouble, right? They're not voluntarily going to do it. So my sense is that, if the state has public interest, because what you want from this law is for firms not to fail. You prefer resuscitation to liquidation, because in liquidation, all creditors will lose out much more than resuscitation. So in the resuscitation, since the government gets involved in a lot of public policy, why doesn't the tax person also participate in that pool? Why are we even prioritizing 1 year? To me, economically, it doesn't make sense to me.
I see your point. Thank you, Mr. Jafferji. And I think, here there is no need for any sort of amendment to the legislation as such. It's more of a philosophical sort of, debate as to how you want to perhaps implement it through regulation to allow, like he said, and also Mr. Vijay Singh has said, to make it a vehicle to bring capital in to Sri Lanka.
There was one example I forgot, Mr. Chairman. There are many unfinished apartment buildings in the city of Colombo. Because we have off-plan, right? You pay paints. All those apartment owners are creditors to that project, right? There is no easy way to resolve this. Now, India basically has that in their bankruptcy law to allow resolution of unfinished apartment buildings. And maybe Chanaka can come, whether this will permit faster resolution of all these half-finished apartment buildings in the city.
I think that can be brought in the regulation level, right? Not in
Does the
act
law
level.
cover that?
Yes, it can be brought under. That is the idea of restructuring. It also permits new borrowings. If you are doing new borrowings for the purpose of resurrecting, then you are given a preference over the existing creditors, because if the company is in trouble, unless you have preference, nobody is going to give you money. So that has been permitted. So yes, that type of a business which is in that situation would benefit. It will, you can take advantage of this.
I think, Chairman, I think we also need to pick this now. This is in a normal circumstances. I think Honorable Member also mentioned at a crisis or a natural disaster, a bad bank kind of a provision is also a very important provision. I don't know whether it's this legislation that we can bring something like that, or or something outside that we have to think like that. But that is also a problem for a country. India and few other countries did that. So when their bad loans were so high, so they basically pull it into a program and resolved it over a period of time, so the financial system runs in a smooth way. But I don't know whether this act, that is something that came up, whether we need to note down that whether this act can cover all of that or something that we need to consider after.
Yeah, this whole thing about asset management companies here, right? How can you answer the Honorable Member's question?
I think it is a very specialized aspect. It is more about managing debt rather than insolvency. How do you manage that kind of, overdue liabilities and so on? I would not bring it under the insolvency legislation, because this is more generic legislation that deals with specific situations. So I would leave that separately and deal with that separately.
Yes.
Can I, following up on Mr. Jafferji's, realistic approach, Chanaka, how do you see, now you're bringing another piece of legislation, but the actual implementation would be the liquidator or the process leader who is going to give leadership to that. How will he look at the capital coming in, or will he only be helpful to make a small company trying to grow be a predator to a big company trying to buy over? How will that process be looked at from your law?
From the law, essentially you're dealing with a distressed entity. Not necessarily, now rescue happens.
No, my question, you didn't get me. Today, banks become the biggest salesperson to a bigger company. They spot something weak, they look at it solvent, so they basically make it a predator activity to a bigger company. How do you see this particular liquidator, or whatever the term that you use, to run that company during this insolvency period? How does he come in with a cash-rich approach in order to make it viable? But he may have a super business proposition, but may not have the capital base to go forward. So then, who does he look at? Who does your liquidator look at to take it forward?
Yeah. So, like I said, this law deals with a distressed entity. Whether it be big or small, it's a distressed entity. Why are the banks in a very special situation? Because the banks have been given special rights. They have the Parate law, which you and I don't have, right? So once they take it, it sits in their books, right? As to what they do with it, I think it's a big problem thereafter, but that's how they recover it. At least the bad loan is dealt with then, right? But what happens there is that the unsecured creditors are compromised, seriously compromised, even in a situation of a viable company, because the bank looks only at its liability, it has the asset, it takes the asset, and the company is destroyed. Now, in those circumstances, this provides, like Mr. Jafferji said, the ability for a company to get it restructured and all creditors to participate, both the secured and the unsecured. So if the company is restructured and it is resurrected, everybody benefits. Now, even in the context of the inland revenue remark that was made by Mr. Jafferji, the priority list looks at how you pay when the company is being put to death, if I may use that form, right? But when you resurrect a company, that company functions and generates more revenue for the government because it is in business, right? So it makes much more economic sense for a company to be resurrected and allowed to function than for it to be liquidated, unfortunately, which is not there in our law now. So that's what this provides.
Next, I want to invite Deserams and Nitya partners, take a few minutes to sort of look at any new, you want to shed new light to this, anything that was not discussed thus far.
Nothing new, from Niti Partners, nothing new to discuss because the concerns that we had about the competence of the infrastructure to handle this new law has been raised and dealt with. So nothing from us at this point. We'll give the time to someone else.
You are from?
Niti Partners.
Nitya. Deserams, you have anything to add?
Hi, we were instructed by the Sri Lanka Bankers Association to review the draft act in a very early stage of its development, and we prepared a comprehensive report on where we think it needs revision. I don't know whether really we haven't had much time to look at this one.
But just one moment.
Yeah.
He said that there is hardly any difference between what you looked at and what's now.
So then that means none of those amendments have been incorporated. So we would like to make comment on this draft bill, if there is time to do so. Yeah.
Nobody retained you this time?
No.
Unfortunately for you. Right. So, I mean, you are saying that
Can you submit that
so that's
observation?
We can.
So what you are saying is you had certain observations, and what you're saying is none of those have been incorporated in
Yes,
here.
so to be honest, we haven't looked at the draft bill in its present form.
Okay.
So we don't know whether our amendments proposed 2 years ago have been incorporated, but if Mr. Chanaka De Silva said that it hasn't undergone much revision since it was first drafted, then very unlikely. So we would like a few days to review this version and comment.
Yeah. Can I make an observation?
Yes, please.
The draft went through several iterations, and those iterations went through stakeholder comments. And many comments that were made by stakeholders were incorporated into the final draft, which was presented in February. So I am not sure whether any comments that were made by the bankers, if they were made, now what...
Your client was the banking association.
Yeah.
Yeah, so they are here. They are here.
Yeah. So if they were made, they might have been addressed, because we went through all the comments that were made by stakeholders. Some were accepted, some were not. And the final draft is what has not changed then.
So could I please ask the Bankers Association to sort of address that and any other issues that they may have that have not been discussed thus far? Miss Himali Mudadenia and Miss Varuni Egodage.
Actually, Chairman, through DSERM's Bankers Association made representation and made that we need certain amendments. Actually, we did not get time because we were informed of this meeting only yesterday evening. So we
Sorry, are you from the Bankers Association? Or from
no, I'm representing the Bankers Association today. I'm the head of Legal Commercial Bank, Varuni Godege.
So did you see the gazetted bill before you, because this was gazetted some time back?
Yes, no.
This was gazetted in March.
Yeah.
Yeah, but I don't think the banks have reviewed it since.
So
then that's... Yeah.
I mean, the invitations went last week. I don't know why people are saying it was, you all were told yesterday. I don't know, I'll check with the strange.
So there's no written submission from Bankers Association, no? It's just that, no.
I mean, if there are, I mean, this is the time, because once, there is no post-enactment legislation, review.
But this has already been gazetted and it has been
in the
public domain
for some time.
Yeah, if that.
I mean, people who are interested should have looked at it.
Counting from when? After presenting in the parliament, there will be 2 weeks to the review, right?
Yeah. This is
still there is
precedent in
time.
Still there's time, yeah.
Has this been challenged in the Supreme Court or something? No. No, it is not. So then, I don't think there are any public...
Can we know the date to make the submissions?
So
the parliament, this will be presented to the parliament.
When would that be?
That is 5th.
So we debated on the 6th.
It will get debated on 6th, but then there is room until it get enacted.
Okay.
So there's provisions in the law.
But
You're making a mistake, Honorable Chaturanga. This is a second reading. Second reading is on Wednesday. So if this gets approved, Speaker signs, it becomes law on Thursday. So I mean, so therefore, if any amendments, you should immediately write to the MOJ. The secretary is here, because it will be the MOJ that will be making any amendments during committee stage, and we can assist the process. But it's through the MOJ that you have to go. Yeah. 2 period. Yeah. So if the Bankers Association has nothing more to add, what I'll do is now we'll move to the chambers. Can I ask the National Chamber is the Ceylon Chamber also here? Ceylon Chamber and the National Chamber. Would you be willing to make some observations?
Honorable Chairman, I represent the Ceylon Chamber.
Yes.
This is an ambitious law reform, and this creates the rescue mechanism. Although this creates the rescue mechanism in terms of, if you consider the rescue financing mechanism, we don't see many provisions on that. Now, especially when you are going through the rescue process, if rescue lenders are not adequately protected by way of the priority, the entire rescue process may fail. So if you consider a process like a model like Singapore model, IRDA, so it gives a well-structured protection modality for rescue lenders.
Just one moment, let me interject here. there is no way to restructure this piece of legislation, this law. This law is done. I mean, here the objective is to take it and see whether we can tweak it this way, that way, so that we can make it better. So we can't go back to the drawing board. I just want to make that comment.
Yes, but if now certain things can be addressed at the when you are drafting the regulation, but there
Sure.
can be but things like the protection by priority. I'm not sure whether it can be addressed at the regulation level.
No, but then that we discussed, no? That we discussed, and basically I think, both Mr. Jafferji and Mr. De Silva sort of had their, say, and I think what Mr. De Silva is trying to explain is that, they are only prioritizing the taxman for 1 year, and then after that he also has to come in queue. So the sort of the equal treatment of all creditors, like Mr. Jafferji mentioned, I think to an extent is addressed there. So because I don't think you can change the law, and that's not our objective either, right? Just to get some additional feedback whether we can tweak it, that's all.
Thank you, Honorable Chairman.
I didn't mean to cut you off. I mean, I just want to make the comment that, we can't get to the fundamental building blocks of this law. Yes, Mr. De Silva.
With regard to rescue financing provisions, there are rescue financing provisions in the law, because that is something which is very important. Like I told you, nobody is going to give funding for a distressed company or distressed entity unless they are going to stand in priority. If they are going to stand in the normal queue right at the back of the queue, they are not going to come and give you money. So that has been addressed here.
Yeah, in fact, section 385, 386, super priority for rescue financing and insolvency professional record. Fourth schedule of the ranks liquidated administrative fees, rescue financing and committee costs ahead of distribution from unencumbered assets. So it is addressed. National Chamber.
Honorable Chairman, I'm Charmika from National Chamber. We in general welcome the entire bill because it is heading towards a positive rescue first approach. But we also agree with a lot of the comments in terms of time bound and then tax provisions that this need to be revived on. Not sure, we've also got the invitation yesterday, just so that everyone knows.
Is an email hacked or something? Because
the
we
letter
sent
itself
it on the
dates
24th.
yesterday. So. But anyway, one more.
Wait. Unless your email is hacked. We have sent it to you on 24th Friday at 11:36 a.m.
Yeah, I guess.
Emails. Unless it didn't leave the building.
The outbox.
Could be. Apologies
Yeah,
on
go
that.
ahead. Yeah.
One more observation that may not have been addressed, but we would also like to share is that does it have adequate data protection? Because usually when you get into these kind of processes, it's very obvious that debtors really try to default in such cases, and if those recoveries are prolonged, then whole process gets prolonged. So we completely agree with the timelines that was stressed here. So even data protection needs to be looked into it from that point of view.
Yeah, I mean, there is an issue there, a practical issue, Secretary, is that, while the law provides for various timelines, 30 days, 14 days, etc., once you go to the district court system, whether there is enough, free time for those people to deal with this, because there are, so many things to deal with in a district court. So whether what you expect in the law, whether it can be actually implemented, and therefore if it is not implemented, that person would then be not in keeping with the undertakings taken. So that would become then another problem. So I think the practicality of implementing this law becomes a serious matter of concern.
Correct. What I meant, there is a lot of protection for the creditors, but the organization itself will be we'll have funds remaining with debtors. No, that's a part that we were talking about, mainly. Anyway, maybe we can get some comments around that.
Yeah, I mean, the point is the company that is going through the bankruptcy has receivables.
Correct. And usually they get into default category very soon, moment they get to know that the company itself is in trouble. So so far as we've noticed, the provisions are not there to enforce
I think
that kind of payment.
it's a very valid point, a practical point. I don't know whether it has been considered. We'll make a note of that and we'll discuss it after the stakeholder consultation. Now let's move to the associations. Shall we look at the Sri Lanka Chamber of Small and Medium Industries?
ගරු සභාපතිතුමනි අපි මම සීනියර් වයිස් ප්‍රෙසිඩන්ට් චේම්බර් ඔෆ් ස්මෝල් ඇන්ඩ් මීඩියම් ඉන්ඩස්ට්‍රීස් මේ සාමාන්‍යයෙන් බින්දුවෙන් පටන් ගත්ත මිනිස්සු අද මහා පරිමාණයේ බිස්නස් කරලා කොයිඩ් පාස්කු පහරේ කොයිඩ් එක ඊට පස්සේ දිගට ආපු ප්‍රශ්න නිසා ඔබතුමාලා දන්නවා ඇති සාමාන්‍යයෙන් බිස්නස් කොහොමද මිනිස්සු රන් කරේ කියලා. කම්පිටිෂන් අඩුයි සෙනග ගොඩක් වැඩ කරනකොට. එතකොට දැන් කම්පිටිෂන් නැති නිසා මිනිස්සු හැම කෙනෙක්ම ගාමන්ට් ෆැක්ටරියක් වුණත් ස්ටිල් ප්‍රැක්ටිෆිකේෂන් එකට එනවා. හරි මේ මට වෙච්ච දේවල් ගැන මම කියන්නේ. මම බින්දුවෙන් පටන් ගත්ත මිනිස්සෙක් මට ලංකා බැංකුවෙන් දීලා තියෙන පොඩි මුදලක්. නමුත් අවසානයේදී 1 බිලියන් වෙනකම් මම ණය ගත්තා. ණය ගත්තේ ගෙවන්න පුළුවන් නිසා. නමුත් මේ ප්‍රශ්න ඇතිවෙන් පස්සේ රටේ ප්‍රශ්න තියෙනවා සාමාන්‍යයෙන් බැංක්‍රප්සි එකයි ප්‍රශ්න නිසා. අවසානයේදී කඩාම වැටුණා. කොහොම හරි ලංකා බැංකුව මට මගෙන් හම්බ කරපු නිසා මිලියන් ගණන් හම්බ කරලා තියෙනවා. මම බැංකුවට ණය නැහැ. බැංකුව මට ණය තිබුණා. පාස්කෝ පාරෙන් පස්සේ මම බැංකුවට ණය වුණා. ඊට පස්සේ මම ගිය අවුරුද්දේ කොහොම ස්ට්‍රගල් කරලා ලංකා බැංකුව මට අතීත දුන්න නිසා මගේ බැංකු 5ක් තියෙනවා. බැංකු 5න් බැංකු 4ක් මම කොට දාගත්තා. කතා කරලා රිවයිව් වලින් කරගෙන ගියා. ගිය අවුරුද්දේ 500 මිලියන් ඩෙට්ස් වලින් සෙටල් කරා. 1 බිලියන් එකෙන් 500 මිලියන් ඩෙට් සෙටල් කරා. අවසානයේදී HNB බැංක් එකෙන් මට රිවයිව් කරේ නැහැ. 2023 ලියුමක් එවනවා. ඔයාගේ මේ ඉඩම අපි ගන්නවා කියලා. ඉතින් කොහොම වුණත් අනිත් බැංකු වල මට සපෝට් එක දුන්නා. ඒ සපෝට් එක මත තමයි කරගෙන ආවේ. නමුත් දැන් මාව ඔක්ෂන් එකට ගිහිලා තියෙන්නේ පරාට කේස් එක හැටියට. දැන් පස්වෙන්දා ඔක්ෂන් කරනවා කියලා කිව්වා. මම අරන් තියෙන්නේ ඉඩමට විතරයි සල්ලි. නමුත් අපේ බිස්නස් එකේදී යාලා එක මුදල් දීලා තියෙනවා. නමුත් මගේ ඉඩම වටිනාකම මිලියන් 60යි. නමුත් දැන් මිලියන් 300ක් 400ක් වෙලා තියෙන පොලිත් එක්ක. ඒතර ගෙවන්න තියනවා කියන්නේ මුදල මිලියන් 200යි පොලිය 200යි. ඉතින් මේක යාලා කියනවා මිලියන් 300කට සෙල් කරනවා නම් ඔයා බේරන්න පුළුවන්. මම කිව්වා මට සතපාකත් එපා ඉඩම ඔයා ගන්න මම මේකෙන් ප්‍රශ්නේ මම බේරලා දාන්න. මොකද මමත් තව බිස්නස් කරගෙන යන්න පුළුවන්. දැන්ටත් මම බිස්නස් කරනවා. ණය බේරනවා. මගේ දැන්ට 100ක් වැඩ කරනවා. ඒ මිනිස්සුගේ පඩි ගෙවනවා, ටැක්ස් ගෙවනවා, ඔක්කොම කරගෙන යනවා. නමුත් මේ මත අනුව මේක මට ගිහිල්ලා මේක අඩුවට වික්කොත් කාට හරි ඉතුරු ටිකටත් මට නඩු දැම්මොත් මට ඒක ගෙවා ගන්න බෑ. මට මේකට උත්තරයක් ඕන මේ උගත් මහතුරුන්ගේ. කොහොම ස්තුතියි.
සංගමයක් විදියට මොනවා හරි ප්‍රකාශ කරන්න තියෙනවද?
අපි කියන්නේ මෙහෙමයි. මගේ 60ක් විතර සමාජිකයෝ මේ තත්ත්වෙම තමයි ඉන්නේ. මම උදාහරණයක් විතරයි මම මේ කිව්වේ. ඒ කියන්නේ ඉස්සර නම් 140ක විතර ලාභයක් තිබුණා බිස්නස් කරනකොට. දැන් ඒව නේ ඕවර්හෙඩ් එක කව කරගන්නත් බෑ.
නෑ මෙහෙම මේ ඇක්ට් එක ගේන්නේ පහුගිය වෙච්ච ප්‍රශ්න විසඳන්නනේ.
ඔව්.
ඒතරද ඔබතුමාලා සංගමයක් විදියට මේ ඇක්ට් එක ගැන අදහසක් තියෙනවද? මොකද පරාටේ ප්‍රශ්නය ගැන අපි වෙනම කමිටුව අපේ දැන් ෆොලෝ අප් එකක් තියෙනවනේ නේද? ඒක මෙතන කතා කරන්න බෑනේ සහෝ.
මම දැන් හෙල්ප්ලස්. මොකද හේතුව එයාලා කියනවා ඉතින් පස්වෙන්ද වෙනකොට මේක සෙල් කරේ නැත්නම් මේක ඔක්ෂන් කරනවා. එතකොට එයාලා සමානලාට බැංකුව අත්පත් කරගනි. ඊට පස්සේ ඉතින් එහාට මොනව වෙනවද දන්නේ නැහැ. නමුත්
දැන් පොඩ්ඩක් ඉන්න මහත්මයා දැන් මේක සාමාන්‍යයෙන් මිනිස්සුන්ට තියෙන ගැටලුවක්නේ. මේක මෙතුමා විතරක් නෙමෙයිනේ මෙතුමා එක්සැම්පල් එකක් හැටියට කියපු දෙයක්. එතකොට ඒක තමයි මම ඇහුවේ දැන් මේ චානක දිසිල්වා මහත්මයාගෙන් දැන් ongoing cases තියෙනවා. දැන් එතකොට මේ නීතිය යම්කිසි විදිහකට වෙනස් වෙනවා. එතකොට මේ නීතිය වෙනස් වුණාම මොහු වාගේ මේ ප්‍රශ්නෙට මැදි වෙලා ඉන්න කට්ටියට ඒ අලුත් නීතිය හරහා යම්කිසි විසඳුමක් ලබා ගන්න අවස්ථාවක් තියෙනවද කියන මම හිතන්නේ ඒක සාධාරණ ප්‍රශ්නයක්. ඔබතුමාගේ මම කලින්වත් ඒක විමසුවා ඔබතුමා.
Chairman, may I?
Just one moment, please. Yeah, I'm
same
asking
line
Mr.
I want to ask from him whether this act supersedes the Parate Act. That is what we have to look at it, I believe, because all the other things are. I'm representing the Ceylon Federation of SME, because if this act come into play, okay, whether this supersedes the Parate law which is enacted, and the banks has taken that act as some people spoke, how they are implementing that act. Whether if it is comes to the second reading and it, as you said as a chairman, it will be enacted. Whether this act supersedes the Parate Act. That's what we have to look at it. And I think Parate has been a curse for this country for a longer time, only benefiting the banks. I just want to add that too. Thank you.
Mr. Chairman, as the President of the Sri Lanka Chamber of Small and Medium Industries, I would like to make this comment. Now with this new act coming in, how will it support the SME sector in Sri Lanka? Because SME is the backbone of any country's economy. How will it support?
Chairman, now, the two things. Going forward, it's going to support SMEs for sure. But I think what your question is, the ones that are in trouble.
I mean, let's not beat around the bush. This is a problem. Whether we like it or not, this is a problem that's not going away, People are getting Parate executed left, right and center. Now, I think these are valid questions. I mean, you don't have to respond to it, but if you wish to, you can respond to it.
Yes, I can respond and I would like to respond. I will try and address all the questions that were asked. May I answer in Sinhalese?
Please.
Yes. මේ සිංහලෙන් කතා කරපු මහත්මයා කියපු ප්‍රශ්නය වෙන අවස්ථාවේදී මේ නීතිය තිබුණා නම් ඔබතුමාට මේ නීතියෙන් සහනයක් ලැබෙනවා. හරි. අවාසනාවකට මේ නීතිය ඒ වෙලාවේදී තිබුණේ නැහැ. මේක යටතේ දැන් ඔබ කිව්වා බැංකු පහක් එක කතා කරලා ඒක සලස්ව ගත්තා ඒක බැංකුවක් කැමති වුණේ නැහැ කියලා. මේක යටතේ එවැනි අවස්ථාවකදී සියලු දෙනාම එකතු වෙලා තීරණයක් ගන්නවා මේ කොම්පැනිය එහෙම නැත්නම් මේ බිස්නස් එක ඉදිරියට ගෙනියන්න පුළුවන්ද බැයිද කියලා. ඔවුන් තීරණය කරා නම් යම්කිසි there are thresholds, I don't know the Sinhala word for it. තීරණ ගැනීමේ සීමාවල් තියෙනවා. ඒ සීමාවල් යටතේ ඔවුන් තීරණය කරා නම් මේක හසුරුවා ගන්න පුළුවන් කියලා සියලු දෙනාම මේකෙන් බැඳෙනවා. එතකොට එක බැංකුවකට විතරක් ගිහිල්ලා වෙනස් දෙයක් කරන්න බෑ පස් දෙනෙක් එකතු වෙනවා නම්. ඉතින් ඒ වගේ වෙලාවකදී ඔබලාට සහනයක් මේක යටතේ ලැබෙනවා. ඒක යටතේ ක්‍රියා කරා නම්. දැන් ඔබතුමාගේ ප්‍රශ්නේ උනේ දැන් මේක වෙලා උනාට පස්සේ මොකද කරන්න පුළුවන්? දැනට තියෙන නීතියක් පරාටේ නීතිය. ඉතින් පරාටේ නීතිය යටතේ යම්කිසි ක්‍රියාවක් කරා නම් ඒක නැවත ආපසු හරවන්න අමාරුයි. ඒක නෛතික ක්‍රියාවක්. ඉතින් ඒක අපහසු ක්‍රියාවක් වෙනවා. හැබැයි ඉදිරියට මේ නීතිය සම්මත වුණාට පස්සේ නීතිය ක්‍රියාත්මක වුණාට පස්සේ සම්මත වෙලා ක්‍රියාත්මක වෙන්න ඕනේ. ක්‍රියාත්මක වුණාට පස්සේ එවැනි තත්වයකදී බැංක් බිස්නස් එකක් ආපහු ප්‍රතිසංස්කරණය කරන්න ප්‍රොපෝසල් එකක් දුන්නා නම් යෝජනාවක් දුන්නා නම් ඒ අවස්ථාවේදී ඒක සම්මත කරන කල් නැත්තම් ඒක රිජෙක්ට් කරන කල් පරාටේ වත් මොනම දෙයක්වත් කරන්න බෑ. නඩු දාන්න බෑ, පරාට කරන්න බෑ, මුකුත් බෑ. හරි? හැබැයි ඒක අසීමිත කාලයක් නෙමෙයි. මොකද ඔවුන්ට තියෙන අයිතිවාසිකම. ඔවුන්ගේ ණය ගෙවිලා නැහැ. ඉතින් ඔවුන්ට තිබෙන අයිතිවාසිකම් අපි නවත්වනවා. හැබැයි නවත්තන්නේ සීමිත කාලයකට. මට මතක හැටියට මේකේ තියෙන දින 60ක්. ඒ දින 60 තුලදී මේ යෝජනාව ගැන සලකලා බලන්න ඕනේ. ඊට පස්සේ ඒකේ තීරණයක් ගන්න ඕනේ. ඒ තීරණය හරි මේ යෝජනාව හොඳයි අපි ඉදිරියට ගෙනියනවා කියනවා නම් අන්න එතකොට ඉතුරු කටයුතු සිද්ධ වෙන්නේ නැහැ. යෝජනාව ක්‍රියාත්මක වෙනවා. ඒ යෝජනාව හොඳ නැහැ මේක කරන්න බෑ වැඩක් නැහැ කියලා කියනවා නම් අන්න එතකොට ඒගොල්ලන්ගේ කටයුතු වලට යන්න පුළුවන්. එහෙම තමයි මේක සිද්ධ වෙන්නේ. එතකොට අර ප්‍රශ්නේ ඇහුවා පරාටේ නීතිය ක්‍රියාත්මක වෙද කියලා. right? පරාට නීතිය ක්‍රියාත්මකයි. පරාට නීතිය මේකෙන් අයින් කරන්නේ නැහැ. හැබැයි මේ නීතිය යටතේ යෝජනාවක් ඉදිරිපත් වෙලා ඉදිරිපත් කරා නම් ඒ යෝජනාව සලකලා බලලා එක්කෝ ඒක පිළිගන්නකල් එහෙම නැත්නම් ඒක ඉවත් කරනකල් ඒක කරන්න බෑ. ඒක කාල රාමුවක් අතරත සිද්ධ වෙන්න ඕනේ. කාලය දික් කර ගන්නත් පුළුවන් අවශ්‍ය නම්. හරි. හැබැයි ඒක ඉවත් කරොත් මේක වැඩක් නැහැ කියලා තීරණය කරොත් සියලු දෙනාම එකතු වෙලා ඒ කියන්නේ වැඩි කොටසක් එකතු වෙලා තීරණය කරා නම් ඒ කියන්නේ එහෙමනම් ඉතින් ඒක රිසරෙක්ට් කරන්න බෑ. ඒක ප්‍රතිසංස්කරණය කරන්න බෑ. ඉතින් ඒ අවස්ථාවකදී නැවතත් ඔවුන්ගේ ක්‍රියාවලියකට යන්න පුළුවන්. මේකේ විශේෂත්වය තියෙන්නේ අර යෝජනාවලියක් දීලා බිස්නස් එක ප්‍රතිසංස්කරණය කරලා ඉස්සරහට ගෙනියන්න පුළුවන් හැකියාව ලැබෙනවා. දැන් අපේ නීතියේ ඒ හැකියාව නැහැ.
බොහොම ස්තුතියි. දැන් කොහොම වුණත් මට සහනයක් ගන්න පුළුවන් ක්‍රමයක් කියන්න පුළුවන්ද? ඒ කියන්නේ මම දැන් හෙට යනවා සාකච්ඡා කරන්න. හේතුව මට කලක් දෙන්න කියලා. මොකද මම ඉඩම විකුණන්න බලන්නේ නැත්නම් ව්‍යාපාර කටයුතු කරන්න යන්නේ. මොකද හේතුව මම බින්දුවෙන් පටන් ගත්ත මිනිහෙක් 1 බිලියන් අරගෙන දැන් 500 මිලියන් සෙල් කරලා තියෙනවා. තව දුරටත් ගියන්න පුළුවන්. මේ ප්‍රශ්න නිසා ඇතුළත තමයි කරගෙන යන්නේ. සමහර වෙලාවට බොහොම අමාරුවෙන් මේ කම්පැනි රන් කරන්නේ. වෙලාවට මිනිස්සුන්ගේ පඩි ගෙවන්නත් බෑ. ඒකත් බොහොම අමාරුවෙන් ගෙවාගෙන යනවා. දැන් හරි ආසයි ඉතින් ලංකා බැංකුවත් උනත් අනිත් බැංකුව උනත් සපෝට් එක දෙනවා උදව් කරනවා. HNB විතරයි උදව් කරේ නැත්තේ. ඉතින් අර 5 දෙනා 4 දෙනාත් එකතු වෙලා ඔබතුමා කිව්වා වගේ අපිට පුළුවන් නම් සාකච්ඡා කරගන්න සමහරට ගොඩ දාගන්න බැරි කමක් නෑ පුළුවන්. මොකද අපේ knowledgeable තියෙනවා.
Yeah.
Mr. Chairman, let me tell you, I think it is a welcoming act especially for the benefit of the SME sector. I think that is supporting. We are very much with it. But we have to, as he has a case, right? So there are many SMEs in that scenario. If you can think of it and think of an amicable solution, we would welcome. Thank you.
බොහොම ස්තුතියි. ඒක තමයි මම ඇහුවේ ඇයි අපි අවුරුදු දෙකක් ප්‍රමාද වුණේ කියලා මේ නීතිය ගේන්නේ. 24 ජූනි මාසේ සම්මත වෙච්ච එක 26 ජූනි තමයි මේ එන්නේ. හරි ඒ අවුරුදු දෙක ඇතුලේ බොහෝ දෙනෙක්ට මේ ප්‍රශ්නෙට මුහුණ දෙන්න සිද්ධ වුණා. ඉතින් දැන් ඒකට කරන්න දෙයක් නැහැ. හැබැයි දැන් ඔබතුමා කියපු දේ මට තේරිච්ච විදියට මේ process එක යනවා නම් ඒ process එක දැන් යන්න වෙනවා. මේ process එකෙන් අලුත් process එකට යන්න ක්‍රමයක් මං හිතන්නේ නැහැ තියෙනවා කියලා. ඉතින් ඒක වෙනම නීතියක් ගෙනල්ලා ස්පෙෂල් මොකක් හරි මට තේරෙන්නේ නැහැ. ඒක යම් විදියකට එමෙන් කරන්න පුළුවන් නම් එහෙමනම් ඒක ආණ්ඩුව පොලිසි එකක් හැටියට බලන්න සිද්ධ වෙයි. නැතුව මේ නීතිය අර නීතිය සුපර්සීඩ් කරනවා කියලා එහෙම හැකියාවක් තියෙන බවක් මට ඇඟෙන්නේ නැහැ.
මම පොඩක් පැහැදිලි කරගන්න හැවුවොත් පරාටේ දාලා නැති බැංකුව එක්ක ඩිස්කස් කර ඉන්න කෙනෙක් හිටියොත් මේකෙන් යන්න පුළුවන්.
මේකෙන් යන්න.
හරි ඒක තමයි. පරාටේ දාලා තියෙනවා නම් දැන් බැංකුවත් එක්ක ආයෙ නෙගෝෂিয়েට් කරගෙනම තමයි යන්න වෙන්නේ. හරි නේද?
මොකද පරාටේ නීතිය බොහොම විශේෂ නීතියක්. ඒකෙන් ඒ අදාළ ඉඩම එහෙම නැත්නම් අදාළ දේපල අයිතිය ලබා ගන්නවා බැංකුව විසින්. එහෙම නැත්නම් අයිතිය වෙන එක්කෙනෙකුට දෙනවා. ඉතින් ඒ අයිතිය දුන්නට පස්සේ වෙන එක්කෙනෙකුට ඒක නැවත ආපහු අර ණය තත්ත්වයට ගන්න හැකියාවක් නැහැ. එහෙමනම් අර බැංකුවෙන් අයිතිය අරගෙන එහෙම නැත්නම් තුන්වෙනි පාර්ශ්වයට වික්කනම් එයාගෙන් අයිති අරගෙන නැවත යන්න ඕනේ. ඉතින් ඒක අමාරු කාර්යයක්. ඒක බොහොම නෛතික ක්‍රමයකින් යන්න ඕනේ කාර්යයක්.
හරි මම හිතන්නේ පැහැදිලි. ඔව් honorable.
Does that mean that the parate execution has to be completed, or if, let's say, the board has taken a resolution but they have not really enforced that resolution? What is the standing then?
Well, what the law says, what this says, I think it's in the section 190s, 196 onwards in this. All enforcement action must stop.
Okay.
So if you have done a resolution but not sold,
right,
you can't sell.
Okay.
Once the rescue plan is submitted, typically if the banks, if there are 3 banks, one bank doesn't agree, is there a process of appeal so that can be, if banks refuse? And if the parties who are present in the rescue plan is interested in, trying to go to another body to try and get this addressed.
Now, the methodology which is given here, I mean, that is why you have these insolvency professionals. The methodology given here is that the rescue plan must come with the blessings of an insolvency professional. So, in other words, you are actually presenting a workable plan. This is not a plan in the sky. It's a workable plan. Now, if a workable plan is presented, and that is accepted by a majority of the people, I think there is a majority of the creditors. There are thresholds which are there. My recollection is about 60%. Then everybody becomes bound by that. But on the other hand, if it is rejected, if the majority feel, no, this is not going to work, then one has to go on the basis that the plan is not a workable plan. Then you can present another plan. Or the bank can take over, the banks or the creditors can take over and present a plan. So, or
Time frame of 2 months.
All within the time frame of 2 months, or extended by them. They can extend. So the law compels the stoppage or the moratorium, as we call it, is for a time period.
දැන් මෙහෙමයි අපි මේක ඉතාමත්ම ධනාත්මක දෙයක් පරක්කු වෙච්ච එක පිළිබඳව තමයි ගැටලුව තියෙන්නේ. නමුත් දැන් මේක ඇක්ට් එක පාස් වෙච්ච පාලියට රෙගුලේෂන් හැදෙන්නේ නැහැනේ. ඉන්සොල්වන්සි මේ මොකක්ද ඒකට කියන්නේ මේ ඔතොරිටි එක හැදෙන්න එපා. ඔතොරිටි එක හැදෙන්න ඕනේ. ඊට පස්සේ ඉන්සොල්වන්සි ප්‍රැක්ටිෂනර්ස්ලා හදා ගන්න ඕනේ. ඊළඟට ඔෆිෂල් රිසීවර්ස්ලා ඔෆිෂල් රිසීවර් හැදෙන්න ඕනේ. ඊට පස්සේ දිස්ත්‍රික් අධිකරණය මේක ක්‍රියාවලිය අර කවුද කිව්වා වගේ ඒ කට්ටිය පුහුණු කරන්න ඕනේ, ට්‍රේන් කරන්න ඕනේ. මේ සියලු දේ සිද්ධ වෙන්න ඕනේ. එතකොට මෙතන ඊළඟට තියෙන්නේ ඔබතුමන්ලාගේ අතේ තමයි මේ වැඩේ තියෙන්නේ. පාර්ලිමේන්තුවෙන් කරන දේ අපි කරන්න. පාර්ලිමේන්තුවේ මේක සම්මත වෙච්ච පළියට මේක මහ පොළොවේ ක්‍රියාත්මක වෙන එක ඩිලේ එකක් තිබුණොත් ඒක ඕගොල්ලෝගේ අතේ. අපේ අතේ නෙමෙයි. අපිට පුළුවන් නීතිය සම්මත කරන්න. හැබැයි දැන් උදාහරණයක් හැටියට ගන්න මයික්‍රෝ ෆයිනෑන්ස් මොකක්ද ඒක මයික්‍රෝ ෆයිනෑන්ස් රෙගියුලේටරි ඔතොරිටි කියලා එකක් අපි පාස් කරා. කැසිනෝ රෙගියුලේටරි ඔතොරිටි එකක් කියලා අපි පාස් කරා. හැබැයි කිසිම දෙයක් වෙන්නේ නැහැ. මොකද ඒවා ඉම්ප්ලිමන්ට් වෙලා නැහැ. රෙගියුලේෂන්ස් හදලා නැහැ. ඉතින් මම කියන්නේ ප්‍රැක්ටිකලි අපි මෙතන දකින දේවල්. ඒ නිසා අපිට පාර්ලිමේන්තුවේ නීති සම්පාදකයෝ හැටියට මේවා තේරුම් අරගෙන ප්‍රශ්න තේරුම් අරගෙන සටන් කළා මේක ජයග්‍රහණයක් කියලා මම දකිනවා. හැබැයි ඊළඟ ස්ටෙප් එක නිලධාරීන් අතේ තියෙන වැඩ.
සභාපතිතුමනි වින්දිතයක් හැටියට මට දෙන්න පුළුවන් සොලියුෂන් එක මොකක්ද?
සොලියුෂන් එක තමයි මේ කට්ටියව ඉක්මන් කරවන්න. ඔව්. No, yeah, that's it. We have time. We got to move. Yeah. So now ඊළඟට එහෙමනම් මේකේ අනිත් පැත්ත banking association said that they have no problem, so therefore we are assuming that the banks are very happy that the Parat execution is getting stopped. But the banks were the ones that were unhappy, no? Banks were the ones that were saying, no, Parate has to go on. Now they are saying the Parate will be stopped. The banks have no qualms about that. Am I?
No, banks are not here even, so.
No, Bankers Association is here, no? Bankers Association is here.
That we know. That's why the law.
That now what the Mr. Chanaka De Silva is saying is completely contradictory to the position that the bank has been holding all this time. So I'm asking you, because we gave you the chance first, you said you have no comments to make.
No, Chairman, Chairman, we will give written comments because we have already given comments as well. So we give us a few days, so we will make the major observations that you want to present, please.
Right, thank you very much. Then the Finance House Association, Leasing Association, those are the two that's remaining.
Excuse me.
I'm sorry. Other chambers?
Yes.
Sorry, please. Yes, Ceylon United Business Alliance, Mrs. Abe Sundara.
Thank you, Chairman. It's a great honor to be here. I believe this insolvency law is not SME beneficiary at all. This law was really passed during the previous regime to attract FTEs, and then it was a credit-driven insolvency. That's what I mean. Looking into everybody speaking on behalf of this, I believe the SMVs don't benefit much out of this. And like Mr. De Silva said, he thinks this is a great thing for the SMV organizations, but I believe it is not, because it only has a 60-day validity period in not going ahead with any sort of action. So what can a SME organization do within 60 days? This is incredibly, insanely not appropriately. I believe this law, if this is being brought into act, SME organizations are going to suffer tremendously, because what is going to happen is this is a multinational protective insolvency law that I believe. Because if you were to look at the taxations, if you were to look at whatever that is being written in this, this is not SME. So I believe if this law is going to be brought into action, there should be a segregation for a different amendment done for SMEs separately. Otherwise, we would suffer tremendously, because this would benefit all small companies, medium rate companies, to be acquired and disposed into bigger organizations, what is exactly right now happening. So it is going to be a chain-oriented beginning, because smaller companies will be acquired by by the banks and given to bigger companies. So this is a dangerous situation. So I believe this act should have a separate. Total separate.
I'm going to do two things. One is, there is a bespoke arrangement for SMEs. That is the question that I asked at the very beginning from the Mr. De Silva. So there you have the individuals, you have the corporates, and then you have a bespoke arrangement for the MSMEs. So the question I asked was originally, who determines, right? Whether this goes under corporate or whether this goes under individual. So when you say there is the MSMEs have been ignored.
I'm not saying, Dr. Chairperson, the MSMEs have been ignored. I believe the MSMEs are not properly taken into consideration. If you were to evaluate the MSME cycle, Mr. Chairman, it is totally different to what the Act will be protecting the company, because our cycle is a very dangerous cycle, because we totally depend on funding from the banking institutes. So our collateral is not much. So our collateral is very limited. The exposure, funding given without exposure, of course, any banking institution wants to reform it and try, because they don't have to obtain anything. But if there is a collateral, first given chance, they would go into more than resolving it, obtaining, trying to go act the Parata Act. So what I'm trying to say is, if you were to look at the SME...
But Mrs. Abe Sundara...
It has to happen through the institution or
not? Mr. Minister, yes, it would happen through the institution, but if you were to really go through the
Now
Act...
we don't have any barrier, because the banks will decide. Now after this, less than 50 million, there's an option of waiving also.
Didn't he mention it is only 60 days?
Yeah, I mean, it has to be time bound, no?
Yeah, so time bound of 60 days, it is adequate enough for a companies of SME magnitude. If it's a multinational companies, yes, there are multiple companies to acquire it. They are willing to, funders will come forward to rescue. Rescue policies can be easily made. But when you look at SME organizations, you have to evaluate long-termly. For them to be rescued within 60 days is not an easy target and a task.
I
So
think there's
what
a
I believe,
misunderstanding. I think
no,
there's a
no, Mr. Chairman, if you were to read and act, I don't know. I have not fully gone through it because I also didn't have adequate time because I was out of the country. But the little I read through and
So let me clarify
spoken,
this. Let us all get clarification because you
Yeah.
are raising a very important point. And
very,
you're
very important,
yeah,
Mr. Chairperson. You please go through.
I mean,
that.
you're a vocal sort of. You've been fighting for this. And
I
you
have been fighting, and this
so
act
we
within
understand your position.
2024 with Mr. Rajapaksa, former Justice Minister, was brought upon with us. We got this act done, but it was not prepared in this manner. That act was prepared for more protection for the SMEs, but this has not much. So, Mr. Chairperson, I would really appreciate.
So this, I think the issue is with 60 days. No, the way I understand is that you are given 60 days in order to get to the next step. And that next step, if you are unable to get to the next step in 60 days, the court may extend that 60 days to another 60 days.
No, that was not mentioned. He said when the bank has
The creditor will extend it for another 60 days. But 60 days is set.
So whatever the period, they can go on extending as long as they get the. But it must be done with consent.
Decision.
But the creditor has to
See,
agree.
Concern with the creditor.
You must understand, these are people with rights. Creditors have rights. You are taking away the rights of the creditors for a period for the benefit of the debtor by this law. That is why the banks oppose the right to give up their parate rights. Right? So therefore, there must be a balance between the two. It can be 60 days. If the legislature feels it should be 90 days or 120 days, so be it. But there must be a balance.
But
you can't take away that right without their consent.
Is there a specific time period that MSMEs will prefer?
No, Honorable Member, I would say that this policy should be adequately, the government needs to intervene with some sort of a body where this, if MSME organizations are to be brought forward with this sort of thing, because there are willful defaulters and defaulters due to circumstances. So these are, Mr. Minister, can I just please? Yeah. So this has to be taken into consideration. Willful defaulters, the banking sector knows. But if it's defaulters due to circumstances, then it has to be taken into a completely different body, because these circumstances defaulters can be rescued very easily. But if they don't have the adequate facility of collateral being given back again to the bank. Now, let me tell you a very small incident. A very, very well-functioning companies, if your MPL, when you go into the crib, and if the crib is being even a little bit distracted, you could never get working capital done. So, I mean, you are a fantastic paymaster. You are paying your loans on time, but sometimes there have been incidents, maybe 30 or 60 days. But if it's been highlighted, you are on 60 days MPL, not for big, you're not defaulting.
Yeah, but then that is outside this, Mrs. Abhishek, that's outside
No, Mr. Chairperson, this adequate time frame is not enough.
Yeah, so that is what.
So that's what I'm trying to say,
we are trying to find it in the legislation that you said, it is up to us to determine
I think what she's basically saying is MSMEs can't be rescued from this law.
It is not easy, dear member.
One moment. This is subsection, section 41, subsection 1. debtor protection moratorium commences when a court makes a debt protection moratorium order. 2. Subject to subsection 3, a debt protection moratorium continues for 60 days from the date on which it commenced under subsection 1, unless, and there are some conditions. So, Mr. De Silva is correct. I mean, it is up to the legislature to determine whether that 60 days is right or whether it has to be 30 or 120 or 180. So, I agree with Mrs. Abesundara that, you need to be able to take into consideration the circumstances of those affected, while agreeing with Mr. De Silva that you are taking away the right of the bank to para execute the mortgage that they have. Right? So I think it's a balance, and it is not up to me, it is up to the government in this case, and MOJ particularly, to amend the 60 days if you wish to.
Chairman, it's normally now at the moment, as I'm a restructuring guy, and I think I have the license to do that. I've been doing so much in the country. Now I have dealt with a lot of banks, and this proposal came to former President RW to in one of our organization presented. Honorable member was there at that time. We had made some comments, but this 60 days, the 60 days as an issue as well, as she rightly said so, because at the currently default comes within the 90 days. If you are not paying within 90 days only, then the circle comes. That's what the crib says. You are failed to make the interest payment or capital. So the
Mr. Raghavan, it is very clear in the law. It is 60 days. It can go up to a maximum of 90 days, and it can be It can be extended for 4 times.
They can.
So, Mrs. Abesundara, what you are saying is you have 90 days. That is 3 months into 4 is 12 months. So if there is concurrence, if you agree, then you can extend this for 1 year.
Chairman, I think we are missing the substance of the act itself, right? Now this act has brought in to save the asset, right? Asset for the interest of the country. The economy. That is where it still starts. So when somebody goes into a level of liquidation or discussion, bank also gives a fair enough time, right? I think more banks have given more than 3, 6, 9 months, then only this discussion will come. So your point of applying for bankruptcy is the point that from there onward 60 days is what's been discussed. So obviously there is a room of, restructuring your organization for a longer period of time. So this is not that's going to happen. I think what we need to distinguish is what is this law. And I think we are now mostly discussing an incident that happens like the Easter attack or some kind of a crisis. How do we act is a different structure. I think those two cannot be discussed in the same act itself.
But is there accommodation in the act for a situation like that?
This issue really occurred after the Easter attack,
Exactly,
bankruptcy, Corona, because if you were to evaluate in 2019 and 2019, our MPL level was only 680 million.
This was there by 2019. We wouldn't have much of these problems as well.
Yeah, so
but the 2019 is an incident. No, now think of a normal situation. People go into bankruptcy in normal situations also. Right? So the problem that you are probably asking is how
I'm not asking that, Mr.
How do you resolve a crisis situation?
So I'm not asking
is there space in the act to get into a crisis situation like that when there's because this is a bit of it's a turbulent time, and I think that.
Let me answer it this way, and I will also try to answer the question that was raised by her. We are not dealing with non-performing loan scenarios or default scenarios in this law. That is determined by the banking provisions and the classifications which are given by the central bank. They tell you how to deal with a non-performing loan or to consider
part of the
a loan
system
being performed. That's a completely different question.
Right.
This deals with the making of a proposal for restructure. When a proposal for restructure is made, that from the making of that proposal, you have a moratorium of 60 days, whether it be personal or whether it be corporate. During that period, the creditors have to get together and discuss this. Right? Now, once they discuss, if there is merit in the proposal, or a majority agree that there is a merit in the proposal, then the restructuring process can go longer. The proposal stage can go longer. Because putting a restructuring proposal in order can't work in 60 days. But on the other hand, you can't also permit a situation just to be for an entity or a debtor to be coming up with proposals and proposals which have no merit. So if the majority don't agree that there is merit in this, then of course the proposal will come to an end. But on the other hand, if the majority agrees that there is merit, then the proposal can go forward. They can adopt it, they can extend the time for consideration, they can amend it, they can appoint their own administrators to do it. So it can go forward on that basis. But for that, the creditor, whose rights are taken away for that period, has to be involved. So the mandatory period is what we are talking about. That 60 days is the mandatory period.
Yeah. I mean, it boils down finally to the legislature, right? I mean, if you want to change it, you can. I mean, it's a subjective thing. Why 60? Yeah. Why not 45? Why not 90? Yeah. So I mean, somebody has to make a call on it.
Can I just ask a question? With your knowledge, Chanaka, that you've gone through this process, what is the period in India? What is being used? Because that's one of the peer countries that we have the similar type of problems.
I can't tell you the specific period.
It is 180 days or...
But these periods are not long.
These not...
Periods are not long.
But India gives the initial period of 180 days.
So
that's the background that we should be looking at. I mean, you're only proposing, so it's the government to take a call.
Yes.
That's what you're saying.
It's the government to take a call.
Yeah, the way things are going, I think the banks also may come under this. The way the banks are being hacked.
Yeah.
You will have the banks coming to be protecting.
Yes, because the moment you do
it's
that,
a dual approach these days. So.
The moment you do that, right, you are also putting a fetter on the banks and other institutions which also handles public money, right, from exercising their rights.
Mr. Chairman, just one more thing.
Yeah,
Very sorry, I understand.
Yeah.
Is there a possibility where there could be a segregation done for the SME on an insolvency on this act?
I mean, it is, anything is possible. The law is made in this building, right? You want to make it 24 months, you can do it. Right? So it is possible and nothing is impossible. Right? We make the law. Right? So therefore, but then there has to be some logic, right? And some balance.
There
and
are
what
absolute rights, don't there?
Yeah. So that is what you are saying, what is that balance?
Can we also come out with some proposal where you all could look into it?
No, I can't. MOJ can.
I think it's possible now. If you really go through that, there's a whole heap of MSME section, and in that it has all these structures. It's probably dates and thresholds. It says if you are below 50 million, it can be written off also. There's a provision like that.
Yeah.
So if those are not enough, we can discuss. But the Act has enabled a specific section for SMEs, MSMEs. So I think that is what we need to look at detail. Maybe you guys can do it, and then bring more proposals to the Ministry of Justice.
ගරු සභාපතිතුමනි
දැන් අපි
නෑ මගේ අන්තිම ඉල්ලීම
මට දැන්
මම
වෙලාව
දැන් මේ ප්‍රොපෝසල් එකේ මම කියන්නේ මේකයි සෙන්ට්‍රල් බැංකින් මෙතන ඉන්නවා නම් අනිත් බැංකුව හතරත් එක්ක එකතු වෙලා මාව බේර ගන්න පුළුවන්ද කියලා අහන්න. එච්චරයි.
ඒක පුද්ගලික ඉල්ලීම. මම මෙතුමා දිගින් දිගට මේ ඉල්ලීම කරා මම දැන් මට හරි that's anyone else that we didn't speak to? We spoke to everyone. I just want to come back to Mr. Vijay Singh one last time because what Mrs. Abesundara was saying is this has been created for this to bring in capital to restructure big companies as opposed to the MSMEs, and those guys are actually left in the lurch. I mean, is there something that you want to add to that?
Honorable Chair, capital.
No, that's, yeah. Go ahead.
Capital is available across the entire spectrum, whether it is MSME or large-scale investors. But the point is, often looking at individual MSMEs can be a tedious process because you have to put the same amount of time and effort of a large-scale restructuring as well as a small-scale restructuring. So that's where the insolvency committee or whatever that's called in the law would have to look at segregating and aggregating similar types of MSMEs.
So that is what she was talking about, aggregating.
Precisely.
Right,
So
she was
that,
talking about aggregating a whole bunch of MSMEs and then sell it off to some other guy.
Or
At
look
the
at
end, it's a sell-off.
Yeah.
Of course.
No, that's-
Somebody has to bring equity.
No, that's my point. That's my point.
correct.
Yeah.
And that's why, this, Honorable Member, the parallel to that are funds. Now, at the moment, aggregation of funds is discouraged via our tax legislation in the country because of lack of limited liability partnership legislation. But so often there are big, what we call family officers in Sri Lanka. Now, I don't want to mention family names, but they can be as large as $100 to $200 million where they are investing in treasury bills, stock markets, etc. Now, we can play a role in advising these family officers in Sri Lanka to allocate 5%, 10% of their capital to look at resuscitating some of these businesses because they will bring their corporate expertise as well. But often looking at the MSME sector becomes rather problematic unless there is a framework or the preliminary data is available through some independent party. So that's my sort of comment.
Actually, now, Thilan, you're just mentioning you're externalizing a local debt. How will the central bank come in to look at that? Your repayment out, these are domestic debt. Now you're going to externalize it.
Correct.
When
No,
you
I'm not.
externalize
I'm talking
the
of even
repayment
family
and all.
officers that are based in Sri
No,
Lanka.
that's you're tapping the local.
Correct. But if you're bringing from overseas sources,
sell your debt out to
Honorable Member, one of the key things we have to look at is land ownership laws in the country. So because
leveraging that.
Yeah, if it is a minority stake, there is no problem. Right? The majority locally owned means if there's an underlying land assets within the balance sheet of that company being restructured, it can be held by foreigners as long as it's a minority stake. But the moment you go majority, that's where I feel that at least legislation you should write into that an asset going through this process that foreigners even temporarily looking at owning land freehold till such time it's converted into a leasehold or whatever. I mean, I don't want to venture into the politics of this. Because we are restructuring the enterprise, we must give legal provision. Now, the SDP Act, Honorable Member, I don't know whether the new Act gives provision for foreigners to own land if it comes under the SDP law. I'm not familiar with the new whether there's a new amendment to that. So similar consideration would have to be given on land ownership.
Right. I think we've had a very, very fruitful discussion. එක point එකක් දැන් අර මේ interest rate ගැන කතා කරනකොට මෙතුමා කිව්වා මේ 100ට මේ 25ට 30ට 40ට ගියා කියලා. ඒතර එතන ඒ conscious decision එකක් තමයි මේ fixed rate එකකට යනවාද floating rate එකකට යනවාද කියන එක. අපි එතකොට ඒකත් මම හිතන්නේ
ඒක සභාපතිතුමා දැන් තියෙන්නේ අපි ගියපු agreement එක අනුවනේ. අපි ගිහිල්ලා තියෙනවා flexible rate.
ඒක තමයි මම කියන්නේ.
එතකොට අපි ඉස්සරහට බලන්න ඕනේ නම් MSMEs වලට මොකක් හරි protection එකක් තියෙනවද threshold එකක් දාලා හරි block කරගන්න. ඒ කියන්නේ එහෙම නැත්නම් නවත්ත ගන්න හරි interest එක accelerate කරන එක නවත්ත ගන්න හරි banking sector එකත් එක්ක කතා කරලා කරන්න වෙනවා. දැන් මේක වෙලා තියෙන්නේ
දැන් floating rate එකට agree වුණා.
ලොකුද කියලා නෑ floating rate
දැන් agree වුණා නම් floating rate
ඔබතුමා
එක
කියන කතාව ගොඩාක් හොඳයි. මොකද ලෝකේ අපේ neighboring countries ගත්තාම ඉන්දියාව, වියට්නාමය, තායිලන්තය, මලේසියාව MSMEs වලට not protection net. They have separate interest rates, separate adequate systems being built for their uplifting of the organizations.
Right. Okay. So now, Hemanan, thank you very much, Mr. De Silva, for participating on the invitation of the Secretary of the Ministry of Justice. It was very helpful. And I think this turned out to be much more than what we expected. And I think there was a lot of good ideas that came up. And I think there is scope for MOJ also to think about amendments to the legislation, perhaps some committee stage amendments. And I think something that we debated towards the end is the number of days allowed. That is something perhaps a very political one, which needs to be considered. What we will do is we will take into consideration all that was mentioned here, and we will submit it to MOJ and to the Ministry of Finance, so that in the next few days, when can we do this? Can we do this by tomorrow? We'll try to summarize everything by, unfortunately we don't have AI here. If we did, we could have done it much sooner. But we'll send it to you as soon as we possibly can, so that you can use it for debate and discussion inside and make any relevant amendments.
Harsha, can I?
Yeah.
The Justice Ministry or Chanaka, could you tell us whether there can be a fast-track court for this? Because sometimes when it goes before a court, those judges may not know the commercial sense. Like commercial courts being brought into existence, can there be, you're looking at the district court now, so whether there can be dedicated court and dedicated judges for this purpose, because otherwise it will be of no purpose at all, because they'll postpone the case till you get a knowledge.
Yeah,
you have a fast track court for dedicated court.
Yeah, Honourable Member, the Honourable Chief Justice is in the process of establishing special courts based on the needs. So this is one of the things which we can promote, and he will certainly understand. Depending on the discussion that we had today, we do understand that it's time consuming when you take the volume of work in the district court. So we will certainly follow it up.
So can that be brought in the legislative process?
Not regulation, perhaps.
No, not the regulation, in the law itself, that it goes before such a court.
Then
I mean,
that's
as
a big
you
decision.
understand the situation, practically how it will be. Because it's going to be another piece of legislation without any practical purpose.
But Honorable Ravi, but it will delay it, no?
No, it just only to incorporate the...
Can I give a response to that? There are negatives and positives of that. The negatives is that you create a new court, you give them work, that work may take a long time to develop. What do you do in the meantime? So the process that has been used is, if you look at our commercial courts, from time to time, when there is relevant material coming, for instance, company work goes to the Commercial High Court, IP work goes to the Commercial High Court, arbitrations go to the Commercial High Court, admiralty matters are in the Commercial High Court. So very specific things go to the Commercial High Court. If in the Commercial High Court you need to have a separate court dealing with a separate subject, I'm sure the Honourable Chief Justice will look at that. So that is a more efficient way of dealing with it, depending on how it comes forward. That is, so with the development of it, you can do that. The second thing we need to understand is, this needs, particularly the personal aspects, need to be decentralized. So they must be available to the people at the lowest level with easiest accessibility. So that needs to be looked at. So if everyone is to come to Colombo, that is not going to help them. So that is an aspect that we have to look at in relation to that. The third thing that we did take into account in relation to judicial delays is that in most of the instances, if everybody is agreed, you don't have to go to court. Things can be sorted out outside.
Just like
the whole process can go
arbitration
outside.
Process.
Yes. But you go to court only if there is a difference of opinion, if there is a dispute. You have the ability to go to court and get an order. So unlike in the current scenario, you're not compelled to go to court.
Okay.
Right?
So it's provided here in the law?
It is provided in the law.
What's the section, Janak?
It is not a single section, it is everywhere. So it gives you the ability to do things, and where you need to go to court, you can go to court. That's how it is structured.
All right. Thank you very much. Let me once again thank KPMG, Sri Lanka Chamber of Small and Medium Industries, the National Chamber of Commerce, FJ&J Diseram, Nitya Partners, Sri Lanka Banks Association. Unfortunately, we couldn't get to the Finance House Association of Sri Lanka and the Leasing Association of Sri Lanka. So if you don't mind, if there is anything that you would like to add, please send it to us in writing. The Chartered Accountant, CA Sri Lanka, Verite Research, we couldn't get to you. Also, if you have anything, please send it to us. Ceylon Federation of MSMEs, Ceylon Chamber of Commerce, Advocata Institute, Ceylon United Business Alliance, and TW Corp Private Limited. So thank you. It's been very useful. I would request the government officials to stay for a little longer so we can sort of finalize things. Thank you for your participation.
You're watching the Life Traveler channel.